Before we begin, we'd like to give special thanks to all of our sponsors for making this event possible each year. Specifically, thank you to CRL FormFox for being our title sponsor for 6 consecutive years. And thank you to our platinum sponsors, Psychmedics, OraSure Technologies, Quest Diagnostics, and Veriforce.
Hello and welcome to another session of Day with DISA. This will be a panel discussion on drug testing trends and expert insights. So excited to have you join us. This is pre-recorded to make sure that everyone's scheduled on the panel worked together. And I'll go ahead and I'll introduce our panel before we get started. So let me start with Faye Caldwell.
Thank you, Morgan. I'm an attorney practicing all over the nation, but I live in Texas and I'm excited to be here.
And Jen?
Hi, everybody. My name is Jen Mora. I am senior counsel with Seyfarth Shaw in San Francisco. And like Faye said, I'm really happy to be here with you all.
And Brooke?
Hi, everyone. I'm Brooke Westall. I'm actually an HR consultant. I run my own consulting firm for HR services and previously was the head of HR for an oil and gas company based in Texas.
Thanks everyone for the introductions. Now we're going to go ahead and get right into the information. First of all, a big topic in 2023 was California AB 2188 and the restrictions on employment drug testing. So Faye, why don't you lead us off here and give us your perspective on the California law?
Thank you, Morgan. I think the first thing that we want to make everyone, and just remind you, because you probably know, that the new law only affects cannabis. Every other drug is the same as it has been. Nothing about this law changes cocaine testing or anything else. So focusing strictly on cannabis. As you all might remember, to put this in perspective, California was the first state to have medical marijuana in this nation back in the mid-90s. It has never had employment protection for off-duty cannabis use until this year. California's taken a unique approach that has not been the approach prior to this time, although there's some states sort of starting to follow some of their aspects. California focuses on evidence of psychoactive drug, Delta-9 THC for the science nerds in the audience, or possibly psychoactive metabolite. Historically, as all of you know, that most workplace drug testing has focused on metabolite. That's in urine and hair. Now, there's no prohibition on employment testing under the law, although I predict that Jen's going to tell us a few things about California law in employment world. But the employers can test, but they can't use metabolite cannabis results to take adverse action unless exceptions exist, which there are very, very rare. So every employer has to evaluate and to balance in their world, from my perspective, compliance with the law, safety of their workforce, and risk for the individual circumstances and how you test. And that's an individual decision by each and every company. So one of the possibilities that we do is, one is people could remove cannabis from the testing panel entirely. Possibly, and that would depend, if it's office workers, maybe that's the right choice. If it's something else in oil and gas, maybe for that company, it's not the right choice. That's an individual risk determination, in my point of view, to comply with the California law. The other option from a testing point of view is to move cannabis testings to a matrix, a sample type that does not depend on non-psychoactive metabolites. And reading the law, you have to get in compliance with it. But what are the factors that really go into that? The first step, I think, is the nature of the work to be done. And again, is it safety sensitive? Is it not safety sensitive? By the way, there is no safety sensitive exception, as we're all used to across the country in many states, for cannabis and for other drugs. There's only one written exception, which is a building and construction trade. Of course, DOT testing, federally regulated, or even state mandated testing is not covered by this bill. So that's a fact that, what type of work is going to be done? Where does an individual company fall? I think for employers, when I'm talking to clients, they're looking at cost for urine testing, which is historical. Some of them are looking at oral fluid testing, which tests for parent drug. Ease of management of the drug testing program. These are all factors that are going to have as we go through 2024. This law is in effect right now to decide for each individual company how to comply with the law, have a safe workplace, and manage an effective drug testing program. So I think those are the key takeaways I have, Morgan, but I'm sure Jen's going to add quite a bit to this.
Faye, before I move it over to Jen, from your perspective, is there any difference in the status between like an applicant and an employee? So if you're doing like a pre-employment.
There are some people talked about that, but if you look at it whole and look at the legislative history, so one says pre-employment drug screening, and then the next section just talks about drug testing and types of fluids. So for me, no, I do not see any difference. As I analyze it. Let me be fair, though. This law is new. There are no regulations for which to look at. There are no court cases that this is what all of us lawyers like to look at. This is, from my legal analysis and analyzing over the country, the best opinion I have at this time. But we're going to have to wait and see sort of how this all plays out. We have not yet seen an indication that Department of Labor is going to come out with guidance, much like New York did yet. But, that is always a possibility. But no, at this moment, and reading all the legislative history and the committee notes, no, I do not see a difference.
Let me move it over to Jen, a labor and employment attorney at Seyfarth Shaw, who's also an expert in the marijuana field. So Jen, why don't you give us your perspective on AB 2188? And we just for the viewers, we did select the panel so that we give you varying viewpoints. And so it's important to understand that, like what Faye said, there's no case law yet. It's a new law. So Jen, what's your perspective on this one?
Thank you, Faye, for teeing this up. I would agree with Faye on most of what she said. I do disagree. I think that the statute is very clear that it does distinguish between pre-employment and during employment. The key is to make sure that you first get your methodology right. And so she talked about that with respect to the difference between urine testing and possibly moving over to something that tests for the psychoactive component. And in my view, that would be moving to an oral fluids test. So I think there's no distinction between pre-employment and employment when you're looking at the methodology. I do think there is a big difference, however, even if you get your methodology right, what an employer can do, whether it's pre-employment or employment. The statute has a specific exception for pre-employment tests if you get the methodology right. And so if an employer, in my view, moves to oral fluids, for example, which tests for the psychoactive, then an employer can continue to take action against a job applicant because that's what the first portion of 2188, maybe 2188 says. The problem, I think, for employers, and this is where my clients have been struggling a lot, is, well, what do you do with your current employees? The statute protects off-duty use, which, in my view, the exception for pre-employment, if you get your methodology right, doesn't make sense to me because in a pre-employment context, it's always off-duty use. The person's never worked for you, right? But employers are really struggling with, well, what do we do with our reasonable suspicion testing? Even if you get your methodology right, there's no test that proves impairment. And the legislature decided in the findings to AB 2188 made some faulty assumptions about the science and said that there's tests out there that prove impairment, and that's just simply not the case. So, I think we're going to get some regulations. I don't know what they're going to do, if they're going to kind of clean up some of these weird things. But what I've been telling employers to do is that there is very, very great risk in taking action against a current employee, even if you get your methodology right, because you can have a situation where you give them an oral fluids test and maybe that test only measures recent use in the last 24 hours and you terminate the person, they're going to tell the California Civil Rights Division, well, I used last night, which is off duty. And the law is very clear. You can't discriminate against off-duty use. And the employer has no way of proving the employee wrong. So we'll see what's going to happen. There is only the one exception, building and constructions trades. That's not defined. The legislative history makes it pretty clear, though, that that's to be narrowly construed. So I think employers have to be careful. You don't want to, just because you have a receptionist, for example, working for a building and constructions company, I don't think they're going to fall under that exception. And I would agree, too. I found it interesting that California waited so long to have employment protections. I know that I would have a lot of clients call me freaking out. Somebody tested positive for marijuana. What do we do? And I would say, well, right now you can do whatever you want. But yeah, now everything's very, very different.
I think that was an interesting discussion there between, Jen's perspective and Faye's perspective. So for the next topic, we're going to move on to Washington and kind of talk about Washington State and their new drug testing law. So Jen, why don't I lead off with you this time? Because I think Washington is significantly different analysis for employers than California, which we just went through. Would you agree with that?
No. Well, what I will say is that I think what California did is they just focused on pre-employment, and they just said essentially employers have to move to, again, the same methodology. In California, the Washington legislature copied the law with respect to getting the methodology right. So that would mean not testing for the metabolites, right? And so, but it was very clear in the statute that for current employees, random, reasonable suspicion post-accident, it's business as usual. Employers can use urine, hair, whatever it is they want. So it's really, it's somewhat similar to California, but not as broad as California. And so far as I read, Washington is saying it's really just focused on pre-employment drug testing.
The analysis that you're giving your clients typically is a little bit more clear, rather than we don't know, we don't have a case, we don't have information. In Washington, there's also a safety sensitive carve out.
Mm-hmm. Yeah, there's the carve outs in Washington are broader, and I will say, in terms of being clear with my advice, I'm very strong in my advice in California about very, very, very risky to take any action against a current employee based on any sort of cannabis test here in California. I also do hedge a little bit when I talk with clients in California about pre-employment, even if they get the methodology correct, because again, I just don't see how it makes any sense for the state to say we're protecting off-duty use, but you can still reject job applicants. Like, that doesn't make sense to me, but that's the way the statute, at least in my view, reads. So I try to always tell them, like, look, I think you can continue as long as you get your methodology, but like, who knows what the Civil Rights Division is going to do when they issue some regulations.
That makes sense. Faye, why don't you give us your perspective on Washington?
Well, I agree certainly with Jen that it's explicitly pre-employment, where California doesn't have that explicitly. I think all across the country, every time that we've gone to employment protection, I don't find it unusual that the science and the legislature aren't matching, because there is a real problem in marijuana legislation, to be honest, that they say, well, if you're impaired, we don't have to work. We've taken care of you. But the science doesn't match up, because we, as Jen said, we don't have an impairment test. So both of these states have that uncertainty, and states have handled it differently, but we can only go in the law. So I find both of these states to be a continuation of legislatures not matching up with the science, which is unfortunate to say the least. What I think Washington has, and I think it's worth noting, again, cannabis only, not any other drug, it does have a lot of exceptions, and it's worth looking at in a pre-employment. It has a safety sensitive exception, what they call safety sensitive, but as we see in many states, safety sensitive is not a defined term and the same term across the country. And in Washington in particular, it's a pretty high standard for a safety sensitive for which impairment while working presents a substantial risk of death. not property damage, not injury. So and the burden is always going to be on the employer to have that job or that job classification be safety sensitive. It's not the applicant who has to defend that. It's always going to be the employer. And my prediction, the crystal ball, is it's going to be read narrowly and construed generally in favor of the applicant. The other thing I think that I want everyone to remember from the Washington law is you can't decide after an applicant is tested that suddenly that's a safety sensitive position. The statute requires that you predetermine that. In other words, so everyone needs to really work on their job descriptions in advance.
Let's just pause there. Everyone
Sure.
listening, if you're testing in Washington and you have safety sensitive employees and you haven't defined them, what should their takeaway be, Faye?
Have a policy, but also not just safety sensitive, but also the other exceptions that exist in the statute. This job falls under blank. I mean, I'm really a transparency person, and to say all of these laws have risk, as Jen has as correctly pointed out, but let's not build in uncertainty when we don't have to. Have a job description, have it thought out in advance. Now, so there's a lot of exceptions that may or may not fall in. I think it's going to be fairly narrow. It's not, again, not property damage. The other thing is interesting, and this is sort of just a side note to Washington that I don't know how it's going to work. In California, people can continue to test, for example, in urine, they just can't take action. Washington has a kind of a twist that an employer can continue to test as long as they don't get the results. I don't even know how that works, but I say that just to understand people need to really read the statute and work with the idea. So in other words, if you're a pre-employment and you're going to, and you don't have an exception, please, I mean, in my mind, either move to the same paradigm, an oral fluid, if you want to go that way, or don't test. Don't have results that you're not supposed to have under the statute. So it has some quirks in it. And so that's sort of what I think about Washington. It certainly builds off a California model for the first time. California is the first, it's not the last. Maine just took some actions close to this in November. So, whether this will be a trend or not, I don't know. Could we have a New Jersey trend where it's actually permanent? I don't know. But it's interesting, but it's taking a lot, and it's in effect now, folks.
I think you bring up a good point that we probably want to hit on really quick is the differences between some of the older laws like a New York and California and Washington. I thought that was interesting, and I didn't put this on our rundown, so I'm catching you guys off guard here. But as I was listening, that's what I was thinking about. Faye, do you want to take our listeners through?
So first off, I love the fact, Morgan, that you said our older laws. Our older laws are 2021. Okay, they're not very old. All of these are very, very new. We have New Jersey, which I still think after 3 years, I'm not sure, folks, what a wire is and how it works. I'm just not sure. We have a lot that don't even talk about this. It just says you don't have to have someone who's impaired or let them use on the job, and they don't help out. So as states and all the states that have explicit employment protections, I'll be honest, either medical or recreational, they're very, very individualized. It is not a national program. You cannot, if you want to, the only way to have a national marijuana program is to not test for marijuana. I hate to be that blunt about it, but that's the reality in which we live. And we're seeing feeding. So if you look at the Maine one, which just came out with no press release, thank you very much, Department of Health of Maine, it changed the testing for cannabis in some provisions, forgot to change it in some other ones. And so it's really left of what does that mean? And that's in effect now. But again, looking at active metabolites or not nearly as clear as Washington. So, and I think, Morgan, we're going to continue, no matter what the status of cannabis is, to continue to see states individually grapple with what protections to give, how to moderate with workplace safety. We don't have a lot of cases in most. We have some, but everyone's an individual. And it just because it, works in Nevada doesn't mean it works anywhere else. So that's sort of what I give on that.
Well, let me bring in Brooke because she's been in the on deck circle here for like 18 minutes. I think we're into this discussion, and I sort of wanted to start off with Faye and Jen talking the nitty gritty of the laws. But as you listen to this, Brooke, what would be an HR, executive level analysis that would go into, implementing a drug testing program or changing it as you hear the varying opinions between, Faye and Jen, which aren't widely different, but then there's a risk tolerance that you have to consider.
Yeah, thank you, Morgan and Faye and Jen. That's been great dialogue. I think the dialogue right here helps explain the current state for HR professionals, right? So we have a couple of situations here. One, you have states that are all doing slightly different things, and it requires employers to pay attention. You can't just write a policy and set it and forget it and know that you're within compliance, specifically if you have employees across multiple states across the country. I think there's also just an education gap, and a lot of HR professionals don't have a lot of time to follow every single thing that comes out in every single state, but they also have to be prepared and ready to implement a policy or revise a policy when each of these laws come out. I think Faye called out some really important things, and I remember 20 years ago I was involved in implementing a safety sensitive program, and it was a much simpler process back then. But now we actually need to make sure that we're staying up to date on our policies, up to date on our job descriptions, and up to date on our job postings in order to be in compliance. And it's a challenge, right? It's the balance between making sure that we're preventing discrimination, specifically around the marijuana testing, but we're also balancing the importance of safety in the workplace.
Yeah, and I think that's an important point that you brought up is, when I started in this industry, every client wanted a policy to cover every state, and so people would try to produce that. And at this point, trying to produce a 50-state policy is just, it's not possible. I mean, Faye and Jen, are you having clients come to you about drug testing policies and still trying to do a 50-state policy?
I'll start. I do a lot of policy writing. I actually am of the view that 99% of all of these issues don't need to be in a policy. The only place where I actually have any state nuance is Minnesota, which they have this weird new law where they redefine drug to exclude cannabis except in certain scenarios. But for the most part, my policies are very generic. I mean, they give enough information for the employee to know what the expectations and consequences are. But as it relates to cannabis, I just put language stating, as allowed by law. And then in the jurisdictions like Minnesota, Iowa, Maine, for example, that have specific drug testing policy requirements, I just do very short addenda. But so helping clients prepare a national policy hasn't been a challenge, at least for me yet.
I think I would agree with Jen, but I'm going to nuance it a little further. You can make a generic policy, but of course the next question is, okay, now I got my policy, but what do I do? What do I do in each jurisdiction? So maybe a better word is a drug testing process has become incredibly difficult. Cannabis is not the only issue, but it's certainly upped the game. It's what I'm calling cannabis exhaustion on employers. I have employers who are highly safety sensitive, really want to do it. And if they get a cannabis positive where they're allowed to test, what am I supposed to do today? I mean, that happens, but I'd agree with Jen. It's not so much the policy, but the implementation and how they manage it when they really need to take a lot of action and want to be it. I mean, the easiest way, and I'm not in any way an advocate of it, is to minimize the drug testing policy, which of course minimizes safety, but but that's what I'm seeing, Morgan, in that is it's not the policy, it's the implementation and process in the various jurisdictions if they wish to continue to take action.
Yeah, I'll just to parrot that. Yeah, I mean, as long as the employer is doing the right thing on the back end. And so I would agree that sometimes I work with clients to prepare manager, HR kind of guidelines and rules so that they can then go to this and go, okay, I'm in Massachusetts, somebody's claiming medical, therefore we should engage in an interactive dialogue. Or I'm in Minnesota, they're in this job. I do agree with Faye, though, that all policies should be very clear about whose safety safety sensitive and who is not. Iowa actually requires that in the statute and case law, and it's just helpful for employees, again, to know in advance. I'm a big fan of due process and making sure employees know what the expectations are.
And so, Jen, are most of these laws workplace, like employment laws? Because I think the question that we get, and maybe Brooke would have on the HR side, is how do we know which laws apply when we're creating these work instructions? And I think that's a frequent question.
So in terms of policy requirements, so you have to keep in mind there's drug testing statutes and then there's cannabis statutes. And only Minnesota has married the two. Everywhere else, Iowa, for example, has a separate drug testing policy requirement in its drug testing statute. California now has AB 2188, but the law is completely silent and there's never been a drug testing statute that talks about your policy. So you have to make sure you're looking at both.
If you're in New York, but the person lives in Connecticut, like what laws apply?
So, and that's a tricky question because a lot of, at least on the medical side, because that's really the only time this is really going to become an issue. If somebody works in Colorado, but they've traveled to Texas for a trip where it's not legal except CBD, and they do something there, then you follow Colorado law and Texas law. And I would take the position, it happened in Texas, you follow Texas law. We can all agree to disagree. Where it becomes complicated is with the medical marijuana laws, because I don't think any of them, and I could be wrong, have any sort of reciprocity with each other. The question really is, if you have somebody who is in Illinois, for example, where a medical marijuana user to have protections actually has to register and get a card from the state, if they have an Illinois card, but now they live in Texas, that's not going to help them, right? But California, all you have to do is letter of recommendation. So if they move and they have a letter of recommendation, so it's not one of those situations where, like in background check world, I can say, follow the law where they live and work. Here, it's going to be a little different, and it's going to really depend on the facts. I'm a big fan of following the most conservative law as well. And by the way, where can you be sued? Follow that law.
Yeah, where can you be sued? That's usually what we like to talk about. Yeah, Faye?
I would say I agree with Jen. I'm going to put it in slightly different words, but really the same, because the biggest question we get is people who are multi-state workers. And I agree that the ante ups for medical, no question. And how I would say that, as far as most conservative, if you want the most risk litigation avoidance perspective, which may not be the perspective of every company, is to afford the donor the most protection available under either of any of the laws, because there have been a few cases in the Northeast where a person lives in one place, works in another. I mean, the point is, but they are highly fact specific. But, again, it really depends on the facts of each one, just as Jen said. But my recommendation is to avoid litigation is give the person the most protection available under either state that's appropriate. And it's particularly as if you're having someone who does for work goes to multiple states, where the employer is sending them rather than just traveling for vacation. But it is probably one of the thorniest questions that comes up. I bet Jen and I get it constantly. That's probably one of the biggest questions we get.
So Brooke, hearing all of this, one of the things I'm thinking about is how the workforce has changed over the last 3 years. So from the HR perspective, it used to be easy to know where your workers were because you had like an office and they went to it. Well, look at this session. We're all in different states. We're all talking. We're all doing this. So how does that change your analysis, and your training, Brooke, with the different states that could be impacted with remote work?
Yeah, I actually think it goes back to, it continues to increase the complexity. I kind of use the same analogy as, now that we have, remote workforces and people traveling all across the country and sometimes the world, we have to think differently about how we tax people in their paychecks. This is in a similar place. We have to be that aware. We have to know where our employees are, where they're living and working, and when they're traveling and where they're working, so that we can make sure that we give the right advice. I think the other thing is, no matter what size of an organization you are, you need to make sure you have a resource that can help you with this. If you're a small organization, there are, a bunch of organizations on the smaller side that can help. A bigger organization might have a dedicated resource that helps in the in-between space between when you need to call your legal advice and when your HR professional just doesn't know the answer. And I think that's critical to navigating this landscape.
Okay, well, we're running out of time here. This has been great information. Why don't we go into one last question? We'll go around the room, and then we'll wrap up. But 2024, it's an election year. Faye, what do you think employers should be watching for as we enter an election year? What kind of things are people gonna be passing in different states?
Okay, so we have a couple things in my mind in 2024 that are possibilities. I won't go likelihoods because the crystal ball is never that clear. First off, there is certainly talk and discussion that the DEA is going to issue their opinion on the possible rescheduling of cannabis before the election. We'll see if that happens, but that would be a game changer. And we can talk about how much of a game changer and how much not of a game changer. But I think in public opinion that the idea of potential rescheduling would make a difference. So that's certainly on the table. The other thing is, in federal election years, there is always a lot of states that attempt to legalize some form of cannabis. I think in 2020 we had 7. The point is, these are voter initiatives, not legislative. And because, as I read, not particularly a lobbyist or anything, but I mean, what you watch is, because there's a greater turnout for the election, people try to get it on. And so there's already talk of 5 to 7 states either moving to additional recreational, trying to move medical. So I think you're going to see a lot of that this year as the legislatures move forward on the state ballot issues to change status of cannabis. And you can then add psilocybin and all the other things to it. So I think it's going to be an incredibly active year. Just what and old data will tell you that if the voters are choosing, not the legislature, the likelihood of passing goes up. The percentage of when it's actually voted for goes up, even if eventually they have trouble with it. So I think we're going to have a very active 2024. I think we're also watching the HHS on fentanyl, MDMA. We obviously have oral fluid issues coming. So I think in drug testing space, 2024 is going to be huge. And as we watch California, Washington, Maine, and all the others change some of this, all I've got to say is, stay with your organizations, watch who you did. There's going to need a lot of advice that's going to be out there in 2024.
Yeah, I think you brought up a good point in driving turnout, and that's kind of why I wanted to put this topic on the table. But one of the things, Faye, that we've talked about earlier on is, you said California was the first to have medical marijuana, and now they're coming back, 28 years later, and in doing employment protections. Do you think that California is setting the model? You talked to me offline about some of the states that already have employment protections, but do we think we'll see increased employment protections?
No question, because Nevada went for pre-employment in 2000. They first up their medical in 2014, and they went for pre-employment a few years ago. I think a prime one is Nevada for current employees. Everyone was quite shocked when the Nevada Supreme Court held that because cannabis is federally legal, current employees had no protection, which if you read all of the studies on when they did it, I can tell you the legislators thought they had protection. I think that's a prime candidate now that it's clear. The other states that traditionally are, I'm going to call old school medical, Oregon, Colorado, the ones that were so concerned in the late 90s of just getting it decriminalized and not worried about employment, I think all of them are potentials. Obviously, Washington has now gone. Oregon, I think, is prime. I think Colorado is prime. Now we're going to have to see how the legislative sessions go and see if that's a mover. This is likely, in my mind, to be much more of a legislated issue than an election issue. It's probably not. These have been handled generally through legislatures, not voter initiatives.
Jen, what's your perspective on 2024 and what we'll probably be talking about at Day with DISA in 2025?
I mean, I agree with everything Faye said. I'm not optimistic anything is going to happen at the federal level. I mean, we've just been talking about it for too long, and I feel like, you know, with the presidential election year, everybody's going to have far more important things. I'm happy to be wrong, but I do think we are going to start seeing even more jurisdictions. I agree with Faye. We'll probably start seeing some of these states like Colorado and Oregon cleaning up their laws. When they wrote these laws decades ago, they weren't thinking about any of these things, and so they just were like she said, they just wanted to legalize marijuana. You know, I kind of tend to think that states are probably going to go along the lines of what some of the more moderate states, not moderate, but New York has kind of gone off the rails. I feel like California's gone off the rails, but we've got some decent laws in Minnesota and Washington, D.C., because they at least strike a balance between safety sensitive and not, you know, preserve some protections for employers. So my guess would be that to the extent legislatures write any protections in the laws, I'm hoping they're going to kind of stay in that middle of the road and not just, you know, throw out everything altogether.
Brooke, how do you balance that? How do you balance the challenges of testing and then the risk and of the safety of your workforce?
Education to me is at the core of the most important part of this. So a lot of employers think it's an all or nothing thing. A lot of employees think it's an all or nothing thing. I think Faye started the session out by saying this, you know, the legislation that just came through in California was based on cannabis, but there's a lot of headlines that don't necessarily tie to what has actually happened. And so getting back to educating people with what we can and can't do, and then setting up programs that are meeting those standards are going to be important for, you know, the ability to create that balance for the long term in the space.
All right. Well, thank you guys so much, Faye, Jen, Brooke. I really enjoyed the conversation. I learned a few things, and you guys made me think, all of you. So appreciate you taking the time to join our panel discussion for Day with DISA, and looking forward to everything that's coming this year.
Thank you for having us.
Thank you.
Thank you.